Good afternoon. My name is Gert Holtzhauzen. I'm a business rescue practitioner, and in the current times we are quite busy with the rescue of businesses. According to the Companies Act, financial distress is a situation where you can't pay your creditors immediately or in the ensuing 6 months. A lot of businesses in their life cycle experience a period of decline. The decline happens due to various external factors or internal factors. External factors usually, if you, for instance, on the coal mining industry, the international prices of coal is dropping substantially as a result of the COVID pandemic. Then it's external and it's not that big an issue for you to control within your company. Internal reasons are mostly pointed down to your efficiencies in the company, which you can manage. When you file for business rescue, the only steps to be taken is that your board must take a resolution that your company is in financial distress. File the resolution with the Companies and Intellectual Property Commission, or the CIPC. The moment they receive it and they affix their stamp to your resolution, your business is in business rescue. What does it mean to be in business rescue? Business rescue affords you a moratorium against all claims that can be launched against your company. So it's a legal moratorium. The legislation and courts expect the practitioner to finalize a business rescue within 3 months. That's not always practical, and the practitioner will then ask for extension to meet all the strict timelines that is imposed by the Act. A typical example would be the SAA business rescue, where the government through the courts and NUMSA through the courts forced the practitioners to publish a plan. It's not that easy to publish a plan within that period, depending on the complexity of the business. What business rescue gives you in the moratorium, it allows you to appoint a specialist, a business rescue practitioner that is totally independent from your company, has got a better credibility with the creditors and other affected parties, and to ascertain that what's happening in your business. Furthermore, the business rescue practitioner steps in as the manager or managing the board of the directors. It's a supervisionary role. All the directors reports to the business rescue practitioner. Any decision made whilst the company is under business rescue without the authority of the business rescue practitioner will be rendered null and void. So, in effect, the practitioner is in charge of all the facets within the business. What happens to contracts in business rescue? The business rescue practitioner is mandated to pen the contracts and can even cancel it through the right channels. Save for employment contracts. The employment contracts are safeguarded under the Labour Relations Act, specifically Section 189, and the practitioner must adhere to the Section 189 at all times. Typical example, once again, is South African Airways, where the practitioners are now forced to incorporate the retrenchments of the staff into a plan before any retrenchment procedures in terms of Section 189 may progress. The staff there are some remedies for the staff, obviously in the Section 189. Excess staff are entitled to negotiate their retrenchment benefits. Usually the Section 189 of the Act stipulates that you can get 1 week's pay for every full year that you've been with the company. Under business rescue, the rescue practitioner, depending on the cash available in the company, will most probably negotiate along the same lines and then also reach an agreement with the applicable trade union that represents the staff. The plan in itself has got to be published within 25 days after the appointment of the business rescue practitioner. So it gives the practitioner effectively 25 working days to investigate the affairs of the company, to come up with a high-level strategic plan, get funding, get everything, all the negotiations in place, and then publish the plan. On the voting meeting for the plan, the independent creditors must vote, 75% of the independent creditors must vote for the plan to get it approved. Then it's preliminarily approved. If there's anything, any changes to the securities of the company, the dependent creditors will vote after the independent meeting, and they will have to support the plan by 50+1%. Once that happens, the plan is then finally approved. The implementation stage of the plan is the crucial part. The Act stipulates that the plan, once approved, becomes a binding contract on all the affected parties or parties involved in the business rescue. And it's a binding contract. So everybody that voted for the plan and the plan is adopted are then bound to execute on the commitment made in the business rescue plan. Then the implementation period starts. That's a post-voting period. And then the practitioner is either very much involved, especially where it's a complex situation in the implementation, or if it's relatively easy and the directors can handle it, the directors will continue with the implementation of the plan. Once it's implemented to the satisfaction of the business rescue practitioner, the practitioner will then take it out of business rescue by filing the appropriate documents at the CIPC. Steps to avoid business rescue. Not that easy, because in the Act, Section 129(7) stipulates that if your company is experiencing financial distress, you must either file for business rescue, or you must inform all your creditors that you're in financial distress, and then you must state the reasons why you're not filing for business rescue. That in itself puts a serious obligation on the duties of the directors. If you don't file for business rescue, it's either closing the business down by voluntary liquidation or just stop trading, if you're in a position to do a voluntary liquidation, or you must file for business rescue. Business rescue is a second chance in life for your business, and should not be regarded as another legal has the same implication as being under administration, which has disappeared from our law. Business rescue, you don't have to be worried about your credit rating. The Act, Section 6, stipulates that your anti-avoidance measures does not allow for any credit bureau or anybody to blacklist you or your company. the fact of the matter is that if something like that is being done, it's against the law. The same applies with creditors that apply set-off against your company, where you owe them money and they owe you money and they apply a set-off. That can't happen in business rescue because the money owed to the company is owed to the company. That's one issue. And the money that you owe to your creditor is another issue. So you can't combine the two and apply set-off. That also helps you to survive the business rescue period. When is it too late to start a business rescue? It's too late to start a business rescue when an application to liquidate your company has already been issued and served on you by the sheriff. That means that you can't do a voluntary business rescue filing, and you will have to approach the High Court for the relief that you seek, and that is to put your company into business rescue. It's very difficult at that stage because any application to the High Court can be opposed to any or by any of the affected parties, especially the creditor who brought the application for your liquidation. The best way to get into business rescue is to file in good time. You, as director of your company, knows what's happening in your company. You know what kind of obstacles lay ahead, and you also know what your sales going to do in the next 6 months. If at anywhere in that 6-month projection period you see that you're going to have a financial distress, that means difficulty to pay your creditors, it's best to immediately file for business rescue. Once you file, obviously the key critical aspect is to appoint a business rescue practitioner. The choice of a business rescue practitioner is usually very difficult because after the promulgation of the Act in 2011, a lot of people jumped on the bandwagon and became business rescue practitioners. Now, only as late as 2 years ago, there were proper regulations put in place, regulatory bodies, to try and regulate the business rescue practitioner industry. Unfortunately, where your chartered accountants got one regulatory body, being SAICA, and Attorneys the Law Society of South Africa, business rescue practitioners at this stage have 13 acknowledged regulatory bodies. So it makes the task of the directors very difficult because you can get accreditation by any one of these 13 bodies. The ideal should have been that we have at most 2 regulatory bodies, but that's my personal view. Furthermore, the CIPC plays a role in that they are sort of the wicket-keeper with regards to business rescue practitioners, but they only act on definite decisions by the High Court. Where the High Court agrees that the practitioner should be removed, that catches the attention of the CIPC and they will react on that specific court order. Various complaints can be lodged by creditors, as was done in the past. The regulatory bodies will deal with it within their own disciplinary codes. And that's not necessarily public knowledge, so it makes it more difficult to understand where you're going. Best is to look at your practitioner, look at his skill sets and the history. The history tells it all. We've got a couple of unscrupulous guys that's chasing money, unfortunately, and that makes creates the perception that business rescue is unaffordable for any small or medium enterprise. Do your shopping. Make sure that you chat to the practitioner beforehand, discuss the fees, discuss his methodology, and make sure that you've got the right guy. After all, you want to save your livelihood, which is your business. With regards to individuals, You've got a unique skill set. That was why you were hired into the company in the first place. Look at your skill set. If you're a typist, you can advertise for typing. It's a activity and a skill that can be done electronically on a remote basis. Get clients, send you the work that they need to get typed, transcriptions, whatever the case may be, and start typing. If you want to appoint a business rescue practitioner or you need advice, go to the Turnaround Management of Southern Africa's webpage and look at the number of practitioners that's displayed there. They're all registered with the TMA. The accreditation will reflect on the next to their names, and make sure you get the right guy that suits your kind of personality and requirements, and make contact. Thank you very much.